regulatory takings, constructive expropriations, deprivations, expropriations, or merely custodianship. So that's a really horrible long title, but it partly demonstrates all the different terms that we have in the U.S. and some other terms that have been developed in South Africa when we talk about the government taking private persons' property. Right? This is a little quote from Aristotle that I'm somewhat of a fan of. It says that, men suppose it requires no special wisdom to know what's just and unjust because it's not difficult to understand the things about which the law pronounces. Of course, probably all of you at this point in your studies disagree with that quite a bit. But as it goes on to state, actions prescribed by law are only incidentally or accidentally just. How an action must be performed, how a distribution must be made. To know this is harder to know what medical treatment will produce health. And you see this played out a bit in this area of what's called takings or eminent domain. And what is a just distribution? What is a just way of dealing with property, particularly when the government has a need to use that property for public purposes, or it has a need to regulate or pass laws that impact people's property or property rights for different reasons? What does justice require? Should that individual be required to carry the whole burden of that public benefit that goes to everybody else? Or should the government have to compensate that person? And how much, right? And as we'll see, the United States and South Africa approach these two things very differently, and particularly because, as we'll see, of South Africa's history, particularly the history of apartheid, which ended only in the early 1990s, and then that brought about a whole new constitutional approach to property in South Africa, which only really recently has resulted in some of the changes we'll talk about today. So there's a lot of slides to go through here, and there's a lot of information. So some of this I will skip over a little bit or go through quickly. But as you can see, there's all sorts of different terms, depending on what country you're in, for this notion of what we call in the United States as taking or expropriations. And the typical taking is about the power of the government to take private property for public use or for a public purpose, and that we call sometimes eminent domain. And then the process of doing that we often call condemnation. So the government condemns your property, takes title to it, and we call that eminent domain. There's also this other area called regulatory takings, which we sometimes call inverse condemnation or constructive expropriation, because it's not really the government taking your property or taking title to it, but it's really government passing laws that tell you what you can and cannot do with that property. And so this occurs or rises to the level, at least in U.S. law, to a taking when it has burdened it so much that it really has a heavy impact on your property rights. So you can contrast, for instance, the U.S. Constitution, right, which is very thin on language. Nor shall private property be taken without taken for public use without just compensation. In South Africa's Section 25, which actually this is only part of, it has actually not just 3 clauses, but 9 clauses, I believe. And so it's a very detailed clause. And we'll talk a little bit more about some of the differences. But what in the U.S. we often call regulatory takings are dealt with, for the most part, in that Section 1 of the South African Constitution, which only denies the ability of government to deprive people of their property in an arbitrary way. If the deprivation isn't arbitrary, it's not going to be a taking. It's not going to be a regulatory taking, and there will be no compensation for it. Section 2 tells you about expropriations, what we would call takings in the United States. And there it says it has to be for a public purpose, and it must be subject to compensation. And we'll talk about how that compensation is paid out later on in the presentation. But whereas in the United States, where compensation usually requires high market value compensation, South Africa allows for that compensation to be significantly less than what the market may provide. Now, the reason for that, in part, is because of the history of property in South Africa and the fact that the majority of South Africans didn't have access to private property, land, and so on. And so there's a whole different approach or view of what justice requires in South Africa to some extent. So the basic rules in the United States, and these are the rules that you'll find on the bar exam. You'll also find them, if you're not from the United States, you'll find them in bilateral investment treaties between the U.S. and pretty much every other country in the world. You'll find it in, for instance, the North American Free Trade Agreement. And these, because they're in these treaties in part to protect American businesses and to protect other businesses doing business in the United States from other countries from having their property taken, right, without compensation. And they also protect, to some degree, against regulations that go too far and encumber one's business interests or property. So it's something we find both in U.S. constitutional law and international treaties. And states, of course, I should say maybe at the outset, states can go further in protecting property rights in the United States than the federal government does. So we'll be talking about a little bit of those differences. So the basic rule is that property is both your personal property and your real property, land. The notion that it cannot be taken unless it satisfies these other ideas is the notion, and the usual case, that government can't take possession and title of that property. In regulatory takings, they don't actually take title, so it's more complicated. But thirdly, it's supposed to be used for a public use, right? And if it's not for a public use, then it's not a proper taking. And there was a whole controversy around this in a somewhat recent case called Kela, which we'll talk about shortly, where they took not for clearly a public use, but for a public purpose, or what was arguably a public purpose. And then again, compensation in the U.S. tends to be fair market value based on the highest and best use for that property. So even if your property is just sitting there, it's not being used, you haven't built things on it, you're not using it to farm or for a business, but yet it could be used for those things and could be sold on the market for those higher things, then you get that higher value than you would just based on your present use of that property. So regulatory takings in the U.S. starts with this case of Pennsylvania Coal, written by Justice Oliver Wendell Holmes. He's probably our most famous all-time justice in the United States. You'll see him in the torts cases and lots of Supreme Court cases. But he said, if you regulate too much, if it goes too far, then you've effectively taken that person's property through regulation, even if you didn't take title, right? So, but of course, how far is too far depends on where you are, right? So in the U.S., the court has relaxed in some ways takings, constructive takings or regulatory takings law, and particularly in states like Oregon and Florida and a few others, it's really very easy for a regulation to be considered a taking and therefore now to require some form of compensation. And we'll talk a little bit more about that later in the presentation. So in South Africa, these regulations that went too far in the Mahone case wouldn't even be considered takings. They would be simply deprivations, which, if not arbitrary, again, there's no compensation. So the current political climate in South Africa is that, in fact, Section 25, their property provision, has impeded the ability of the government to go far enough to effect even more transformation, to keep going and redistribute more property and give South Africans more access to land and private property, right? And so in North Carolina, I'm not sure what the rule actually in North Carolina is, if that's the question. I don't believe North Carolina has passed progressive regulatory takings laws. I'm pretty sure North Carolina simply follows the Supreme Court majority rule on this, which I'll go through here in a few minutes. So the U.S. Constitution uses this term public use. South Africa from the beginning said in their section that it not only applies to taking for public use, like taking to build a road or a public school or a prison, but also for public interest, things that are good for society, things for economic development. And that comes up very strongly in this Kela case. Secondly, that distinguishing between deprivations and expropriations almost completely gets rid of all notions of what's called regulatory takings in South Africa. It's almost impossible to have a regulatory taking there. But third, and this is maybe the most important point when it comes to takings, is that South Africa requires just and equitable compensation based on a whole lot of factors that take into account the history of the property, the history of government intervention in the property, and so on. And so you may get very little to no compensation for an actual taking in South Africa. So Kela was this famous case that caused a lot of stir throughout the United States. The Supreme Court of the United States actually said that a city could condemn a private person's home and transfer that home to another private developer to facilitate economic development for that city. So they took a relatively blighted area. They forced everybody to sell their homes effectively to the government. And then the government turned around and gave that property to a private developer. A lot of people said, well, that's not a public use. The Constitution says public use. But the court said public purpose is good enough. And there were earlier cases establishing that public purpose was enough. This caused widespread reactions through the United States, with 23 states changing their eminent domain rules so that it wouldn't be possible for the government in their state to take from one person and give to another person. So in other words, you couldn't take just for economic development. You couldn't take poor people's houses and give it to rich people so that they could build better and bigger hotels or condos or things like that. And you can see from here that a lot of states actually passed these reforms in response to Kela. In Florida, they restricted transfers of private property to other private persons for 10 years. So if they condemned your property, the government couldn't give it to a developer for at least 10 years. You couldn't do it to what's called abate a nuisance. So you couldn't say that an area was too low income and had too much crime or created a nuisance and then kind of condemn that whole neighborhood and sell it to someone else. Florida says you can't do that. And they further said that if you want to condemn property and transfer it to private parties, you're going to need a supermajority of the legislature in order to do that. 3/5 of the legislature in order to do any of these Kela, what we call Kela type, taking from the poor and giving to developers to affect economic development. Now, in South Africa, you could do this. You'd need to pay compensation, but again, it may not be market compensation. So when it comes to the black letter law on regulatory takings in the U.S., The general rule is that there's three categorical categories that make a regulation a taking. One is when the government has occupied part of your property. So they might not have taken title to it, but they put an easement, right, a sidewalk through your property, or they run a cable through your property. If they do that, then they have to pay you just compensation, right? Or if they adopt a regulation that basically means you can't use your property at all for an economically beneficial use, then that's going to be a total regulatory taking. The third category is when they say, okay, you want to develop this land, you want to build a new community. Well, in order for us to allow you to do that community, we want you to give us public roads or access to sidewalks or build so much parking or allow so many parks within your development. These are what's called exactions. So the state exacts from you certain things in order to allow you to develop. And the idea there is that whatever the state's asking you to do in order to allow you to do that development, it must be roughly proportional to the impacts that your development's going to have on the property or on the neighborhood or on other government resources like traffic and congestion, crime, pollution, waste, and so on, right? Most cases end up in this what's called Penn Central balancing area, right? This is something that everybody hates about constitutional law, because there's almost always some kind of balancing test, and nobody knows how the cases are going to turn out, right? Most cases under Penn Central end up not resulting in a taking. So the government often, or the courts often view this balancing fairly conservatively. So if you have a regulation that hasn't taken away all economically beneficial use, but still has a really high economic impact, they could still say it's been a taking that requires compensation if the impact is really high, if it really undermines your legitimate investment-backed expectations. In other words, you bought this property, and you put money into it with the legitimate expectation that you'd be able to develop it, put up a high-rise building or put a factory there or farm the land, and then they pass these laws that make it impossible for you to do so, then it may in fact be considered a taking. But if you knew the land was already regulated, if it was already zoned so only certain kinds of businesses were there, then it's probably not going to be a taking. The court also balances the importance of the government's action, the character of it, public purposes behind it, and so on. Is it for historical preservation? Is it because, there may be problems with overcrowding or problems with expanding cities into areas that may not be safe because of prior contamination? Things like that would undermine your ability to claim that there had been a taking. But the courts are really generally kind of conservative. And so are arbitrators, by the way, when it comes to regulatory takings in those investment treaties. It's hard for a regulation to be strong enough to count as a taking, right? That's very different in states like Oregon and Florida, and to some extent also in states like Mississippi, Texas, Louisiana. In these states, Oregon, you can see in the first little paragraph, it says, owners of private real property are entitled to just compensation equal to the reduction in the fair market value or modification or removal of the regulation. So if they pass a law in Oregon that makes it so that you can't conduct certain business on your property, limits the amount of, buildings on your property, and that reduces the fair market value of your property, they either have to compensate you for that or they have to take away that regulation. Well, in Oregon, that resulted in a disaster because thousands of people made claims. the government couldn't pay out the claim, so they simply had to waive all of that regulation. Some of that regulation, some of these cases were brought by, for instance, by adult businesses that sold pornography or had nude dancing in them. So a number of these businesses where the city zoned them and said that they could not do these kinds of activities, they sued and they won, so they had to allow them to carry on this. So Oregon then immediately changed their law and exempted these kind of things from them, and that's what you see in the last paragraph. Florida's law, though, is still on the books, and it's still good law. And in Florida, basically the idea is if a regulation inordinately burdens an existing use of real property or a vested right to a use in property, then again you get compensation for the actual loss to your fair market value. Other states have done this in a way that's maybe a little smarter. In Mississippi, they only allow it to be a regulatory taking if it's devalued your property by 40% or more. Texas, it's 25% or more. Louisiana, 20% or more. So in those cases, when there's a small change in your market value based on a rezoning or a regulation of what you can do with your property, you're probably not going to sue unless it's a really serious impact on your property. Florida, there's a case actually involving the city of Jacksonville where we are now, where the city rezoned a neighboring property, and that impacted somebody else's property. And of course, the problem there is that you could have something be zoned down the street or around the block that may impact your property value. If, for instance, they change the zoning and allow for a new dancing place down the block from you, and a liquor store and a gun store. Those kind of things tend to reduce the market value of your place, even if you're on the next block or a couple blocks over. So that's actually working its way through the Florida Supreme Court as we speak. So how does all that contrast to South Africa? So while in Florida you can sue for any regulation that, in terms of zoning, that impacts the value of your private property, in South Africa you can't, right? So this again is section 25, and again it distinguishes between arbitrary deprivations and expropriations, and then it gives you this list of things in section 3 of how to determine what the fair compensation would be. What is just and equitable? Here they look at the current use of the property, so they don't necessarily give you the highest and best market rate for your property. They look at the history of how you acquired the property, because in South Africa, you might have acquired it in a way that wasn't really particularly egalitarian. And the government, in fact, under D, might have helped you buy that property. The government may have subsidized it, may have made improvements to the property, given it to you or sold it to you for below market rates. The market values also take into consideration, right? But they also look at the public purposes, the purpose for the expropriation. And then other sections further go on and say, look, when we're looking at the public interest, we're looking at the nation's commitment to land reform, to allow equitable access for all South Africans to access these natural resources. And then there's other provisions that go on and talk about equitable access to land, to water, and to redress past racial discrimination in South Africa. So you can see what is a just and equitable distribution can be anything very much short of fair market value based on the history and the purpose of the expropriation. So the case that really is the big groundbreaking case in South Africa came out a couple years ago called Agri South Africa. And the facts are somewhat complicated, but it used to be in South Africa, like in many parts of the United States, that you have a right both to the top of the land, right, the surface of your land, and to all the minerals and things underneath the land. Well, like in the U.S., you could buy and sell those things separately. So you could live on the top of the land, and you could lease or sell even the mineral rights to an oil company or a mining company to extract the mineral rights underneath, right? There's a lot of kind of fancy property terms in here, which all are about your ability to sell and lease and rent and get loans for that separate property. Well, after they passed this law, they basically took away those rights, right? So they made it so that it froze your ability to sell or lease or cede to anybody else these other rights. You had to convert them into what's called New Order rights. And it also took away your right to what's called sterilizing those rights. In other words, you no longer in South Africa have a right, if you sit on mineral rights, to not use those rights. You can't just let your field sit there. You can't let those minerals just sit in the ground. You do have a right to apply for the right to mine or to drill for oil or try to extract those minerals. But if you don't, the government may actually give the right to take those minerals out of the ground to somebody else, right? So was this a taking? Well, at the trial court, they said, yeah, clearly this is a taking. They took away part of your property rights. They took away your minerals. When it got to the Supreme Court of Appeal, which is not quite their Supreme Court, they said, no, it really wasn't a taking. And some members of the court said, well, in fact, they got compensation because they got the substituted new rights, which were a little bit less than the old rights, but nonetheless, not really a taking. When it got to the Constitutional Court, the court developed this whole new concept. It said they didn't really take it, they just held it as custodians for the South African people. They held that they didn't really take title, right, to that property. So the government wasn't taking your mineral rights and using them themselves. The government wasn't going to drill for oil or try to extract precious metals from underneath your land. They were simply taking that property and holding it for other people to apply to take that property out of your land, right? It's in a sense very similar to what they did in Kela right? The state didn't really take and keep your property. They took it temporarily in order to give over to a developer in Kela. Well, here they said, that's not a taking at all. This is really just custodianship, right? And why did the court come to this conclusion? Well, if you look at the reasoning here, a lot of it is that we don't want to overemphasize property rights, at least not at the expense of the state's social responsibilities to affect transformation, to correct this gross imbalance between the haves and the have-nots, and the fact that 87% of the land were given to only 13% of the population. And so there's this whole idea that you need to address gross economic inequality, and this was designed to facilitate this, and it's in line with the spirit of the Constitution, right? And so the court goes on and talks more about the gross inequality, the idea of broadening access to business development. It's about job creation, equitable access, all of these great social things that are done. And of course, from the perspective of the property owner, they're saying, well, all of these things are done at my expense because you're kind of taken from me and given to everybody else. But nonetheless, since the way you probably had it and the fact that you may be not even using it at this point means that, you know, the government is allowed to take custody of your property in order to make sure either that you use it, you apply, and you actually try to access those minerals, or that somebody else gets to try to do it if you don't. Right? So what happens afterwards? Well, after this judgment, the Parliament goes back and drafts a number of other bills that are in the works to becoming law. And one of them deals not just with the mineral rights now, but all agricultural land. And that bill makes all farming land the common heritage of the people of South Africa, and makes now this Department of Agriculture, Fisheries, and Forestries the custodian of all of that. And what that may mean, and what people are somewhat afraid of, is that may mean that now not only the mineral rights might be taken from farmers, but their land rights, their agricultural land, might be taken from them. And the fear is that you might have what you call land grabs, which happened in Zimbabwe and has effectively ruined that country. Or there's going to be lots of regulatory taking without any compensation. Or if the court does consider some of this now under this new legislation as not really being custodianship, but a taking, that these farmers will not really get market compensation for what's been taken from them. And of course, from the government's perspective and the perspective of history, a lot of those farmers got those farms for little to no money, right? The black South Africans have worked those farms and worked those mines forever, making tons of money for those white South African farmers and miners and everybody else. And so justice in South Africa may require less than market compensation. So a couple of other sort of contrasts. This Hodel case is a little bit of an odd case, but in this case, again, in the United States, the government never took title to this Indian land or this Native American land. They simply passed a law that said you couldn't divide up property in this way so that you have all these different people inheriting land. If it was too little, it reverted back to the tribe because it was unmanageable. The court said, no, that's still taking. The second case in South Africa wouldn't have been a taking at all. It looks very much like the case of a custodianship situation. A person actually digs a channel connecting their pond to the ocean, and under federal law, it becomes a navigable water. Navigable waters all come under federal rights of way, and so basically the Corps of Engineers in the U.S. said that means that anybody can ride their boat from the ocean now down into your pond because it's a navigable waterway. And here, clearly, the government didn't take title to that pond or that waterway. It just allowed access for other people to be using it, right? This would be a classic case of custodianship in South Africa, not a taking. But in the Kaiser case, the Supreme Court said this was clearly a taking of that property right, that right to exclude other people from your land. So the last case I'll talk about is actually a very complicated case. And so I'll kind of talk about it superficially and somewhat quickly because it's so complicated. But, you know, back in the 1930s, we had this thing called the Great Depression, and it was very hard for farmers, milk producers, and raisin growers to make a living because prices were going way down, people were overproducing. So they passed all these laws to try to stabilize the amount of crops that were grown and stabilize prices. And these regulations have been around since that time. What it required is that for raisin growers, they had to set aside a certain amount of their crop and give it to the government. The government would then take it and use it to promote raisins around the world. They'd sell some, donate some, sometimes they'd dispose of them, if there was too many raisins on the market, and they would advertise. And then if there was any profit left over from the raisins that they had, they would give that back to the farmers. Well, these horns, they said, well, that's a taking. You've taken our property and you haven't compensated us. And there was a genuine question. It got all the way to the Supreme Court again. And usually these cases don't get to the Supreme Court unless lots of people disagree, right? Well, arguably that right wasn't completely destroyed. It was a regulation, a complex regulation that made them hand over some of their raisins, but then they got money back, right? And the whole idea of it was to increase the price and value of raisins generally. Well, the court said, no, that's a taking. They lost part of their bundle of property rights. They no longer got to possess, use, or sell those raisins because the government took them and sold them and or used them, and so they must give them just compensation, right? Well, what should that compensation be? Well, the court said it should be fair market value, which was $483,843.53. Now, not everybody on the court agreed with that. Justice Breyer, in particular, agreed that there had been a taking, but he thought that the court should have done something like what they would have done in South Africa, and that is ask how much of the value of those raisins was impacted by the government program itself. Because the idea was that their raisins that they got to keep sold for more on the market because of this whole program that the government ran. And everybody else put in their raisins into this program, and these folks benefited from everybody else participating in the program, but yet they got the benefit of not from, participating in the program, but still getting compensated for the supposed taking that took place, right? And so this is some more of Justice Breyer's notes or reasoning. And they said basically they just should have been remanded because they received effectively a windfall. They got a double compensation. They got not only the higher value of their raisins based on the government program, but now they get the fair market value of those raisins from the government that the government was taking from them, right? So that's basically it. So that's an example that if that case was brought in South Africa, they would have said, well, how much of the value of those raisins should have been based on the value that you have created by this great government program. Now, some people think the government program didn't add much value, but the point of the justice was it should have been remanded back to the district court to really see that question, right, to have a trial to find out how much of that value was in fact impacted by the government program. So in sum, easy in some parts of the U.S. to get compensation for even small regulatory takings that impact your property values a little bit. Very hard if you're in South Africa to ever get compensation for a regulation. And now with this new concept of custodianship, difficult even to get compensation sometimes for what would look like a full-blown taking in the United States.